Well, I mean, I'm afraid that we don't get there personally. I think if I was thinking of a way forward, it's something which I would say generally around how we view and construe constitutional rights. And this is an appeal I want to make to judicial authorities generally, because these issues about people's rights will continue to come up in the court, not only in this contest, and especially even in this contest, we are being careful to say that the judgment only applies to these two. So it is likely that other individuals who may be affected in similar ways may also be compelled to go to court of their own if the GES does not take the initiative to set proper codes in place. So my appeal then is that when courts are construing constitutional rights, we should not let ourselves forget that in this country, rather than right, it is power that has been more frequently abused. And yet, those who call power to account and those who are calling for rights to be respected are unfortunately more rigorously scrutinized as opposed to those who call for more power to be given themselves and more likely to abuse it. So this is kind of the framework in which I'm hoping that courts view this. Most importantly as well, as a matter of going forward, I think that one of the things we've seen in this case is the question about balancing of rights and the balancing test. Now, the Supreme Court says all the time, the judge in this case also relied on the same to say we must balance. However, one of the things no Ghanaian can say confidently and accurately is that what exactly is the balancing test we use? And so for so many times, all the courts will tell you that we are balancing this right versus this public interest, and we don't know how the balancing process is done. You know, in this case, you may get, I think this judge got closest to setting out the balancing test, which we do not often see. A lot of times what you get is a description of the right, some long soliloquy about the etymology of the right, you throw in some dictionary definition, then you say, I have balanced it. My hope is that, you know, that the Supreme Court, the backstops at the Supreme Court, that they would set out a proper test. And now there's examples that have been used in other jurisdictions. And since we are not shy from looking at what other jurisdictions have done, for instance, in the modern purposive approach that we took from Israel, that we would look at, for instance, the three-stage test which has been developed in other places where we say, first, it is not the right that must be justified. It is the limitation to the right that we need to justify. And in justifying limitation to the right, the first question is whether there's a compelling governmental interest that we need to protect. And if there's a compelling governmental interest we need to protect, whether the steps we have taken to achieve that goal or interest are narrowly tailored to achieve that. And then when we do that, then we go to the next question as to whether there are more less restrictive means for achieving that same interest. So in this particular case, for instance, there's a legitimate government interest in discipline in the schools. The question then becomes whether, is there any other way to achieve this discipline, or must Magé and Nkrabia shave their heads as the only way in which we can achieve discipline in the schools? So if you put that test there, it will better guide lower courts in how they analyze rights and how even advocates advise their clients.
All right.